Can DCPP terminate my parental rights?
In New Jersey, termination of parental rights is governed by a statute referred to as Title 30. In Title 30, if the court makes a finding by clear and convincing evidence of 4 prongs of the statute, then ultimately the court can order that your parental rights be terminated. DCPP does not have the authority on its own to terminate your parental rights. It can simply file an application in court and ask that the court order that. Now, normally, the request by the agency to terminate parental rights does not come simply because an allegation of child abuse or neglect has happened, or even several allegations. The agency is required, in most instances, to seek reunification of a parent and child, even if a finding of child abuse or neglect has happened. So they're going to be working with you on providing services to try to address whatever the harm was. They're going to be looking for information from those service providers to confirm that you can safely parent, that your child is not at harm, and then ultimately they will only file a complaint for guardianship, which is termination of your parental rights, if they feel they can prove by clear and convincing evidence that ultimately your child is going to do better not having any further access to you. But because that is such a draconian outcome, that is something that is not lightly undertaken by the agency, and it is something that is not lightly granted by a court. All throughout the process, from the time the agency gets involved until the time they file a guardianship complaint, you should be consulting with a DCPP attorney to both prevent them filing a guardianship complaint, as well as to defend it if ultimately one is filed.